Mode.
Welcome and thank you for joining us today for this NZLS CLE webinar, Practicing on Own Account. My name is Alex Jarman and I'm today's moderator. We have two presenters today, Paul Collins from Auckland and David Murphy from Wellington. We also have Sarah Inder here in her role as Secretary for the Practice Approval Committee, who will assist with answering questions when appropriate. When Paul and David begin their presentation, you'll see their faces as well as the slides. Runtime for this webinar is 90 minutes, including time at the end for questions. There'll be no break in the webinar, but if you need to pop out during the broadcast, you'll be able to catch up on missed parts via the archive copy. At the end of the webinar, I'll tell you how to access it. You will already have received an email from NZLS CLE with a PDF copy of the PowerPoints to be used today. Your microphones are muted during the presentation, so background noises don't interfere with the webinar broadcast. We encourage you to participate in the webinar by sending in questions during the broadcast, and now I will explain how to do this. You should now see the webinar toolbar slide. If your control panel is a small box on the right-hand side of your screen with three icons going down. Click on the orange arrow to expand your control panel to full size. Now that your control panel is expanded, you can use the orange button to show or hide that control panel as you wish. If you'd like to permanently show the expanded control panel, you'll see three menu options on the top right of your screen. Click on the View menu. On the drop-down menu, make sure that the Auto Hide control panel option is unticked. To ask questions during the webinar, you'll need to enter your questions into the area near the bottom of your control panel called Enter a Question for Staff. The presenters and Sarah will answer as many questions as time allows. Thank you to those of you who have already sent in questions. Thank you for joining us once again, and I will now pass you over.
Good morning. I'm Paul Collins. Thank you for joining us today. I'm going to be talking to you about the legal aspects of practicing on own account, the regulatory regime and some of the case law in this area. And I'll pass you over to David.
I'm David, as Paul's just said, and I'm going to deal with some of the practical aspects of applying for and obtaining approval for practice on own account. As you'll see from the slide on the screen, this is a major step in your career. You may hitherto have been employed as a sole practitioner or a partner in an employee in an existing firm, and you're going to move from that status to being a sole practitioner, a barrister, a director or a shareholder in an incorporated firm, or a contractor to a government department or a company. And as you'll see from the presentation, there are major changes ahead for you. As a self-employed lawyer, you'll be responsible for all the commercial aspects of the operation of your firm. You'll need to hire staff. You'll need to arrange premises and presumably a lease. You'll need to arrange financing from your bank. You'll need to deal with accounting. You'll need to deal with GST. You'll need to deal with professional indemnity insurance. And if you're operating a trust account, you'll need to run the trust account and make sure that you comply with all other regulatory requirements. These are big steps to take because you are changing from the protected environment of being in employment to being out in the chilly wind of self-employment where you're responsible for all these things. This paper is about the preparations that you're going to need to make for that. Very importantly, the planning and education that you will need to undertake in particularly the Stepping Up course, and also making some self-assessment of how suitable you think you are to go into practice. Now hand over to Paul.
Thank you, David. Now I'm going to talk a bit about the regulatory framework and purposes. This is something of an overview, and I'll begin by saying that as we get to the area that I'll be talking about, concept of suitability, it is obvious and probably self-evident that competency in the law is one of the attributes of a suitable person to practice on own account. So right at the beginning, I want to say that your familiarity with and confidence with the concepts that we're dealing with here is an important part of your preparation. And of course, an ill-prepared application will not inspire confidence in the decision maker, whether that's the Law Society or the High Court. So to begin with the overview, that these statutory purposes are best seen as achieving two objectives. The first is the objective of public protection focused on competence and the concepts of suitability and satisfaction of the practical legal experience requirement. The other statutory objective is, of course, accommodating individual lawyers' legitimate expectations to practice and to advance their professional and business careers autonomously. Now, by virtue of the fact that you're interested in practicing on own account, I will safely assume that our audience has passed through the screen first on admission and subsequently, of course, being eligible for and having been granted a practicing certificate. Therefore, you're already familiar with some of the concepts that we will be interested in today, and in particular the standard of fit and proper person. However, it's important to understanding the practicing on own account regime that it has a separate focus, an additional focus to the fit and proper person standard, and that is embraced in the concept of suitability. And one of the cases in this area, and I should say that there is not a lot of jurisprudence from the courts in this area, but such as there is discussed in the paper. But in a case called Zhao in the New Zealand Law Society, Justice Koch said of the practicing on own account regime, it is not a question simply of character or of fitness, but of the suitability of the person to take charge of a practice. That is a different inquiry, distinct from the fit and proper person standard. A person who is suitable to practice under supervision is not necessarily a person suitable to practice on their own account, particularly as a sole practitioner operating a trust account and handling client money. So the concept of suitability transcends fit and proper person standard and focuses on the ability, and I say the convergence of three strands really, the professional competency, the ability to run a business in the commercial sense, and the ability to run a professional business, observing the rules of conduct and client care and other principles of professional responsibility. Now, the framework is comprised in sections 30 and 31 of the Lawyers and Conveyances Act. 31 is will be of less interest to most of you, that relates to people recommencing practice, and I'll talk about that later. But section 30 is the core provision in the Act, then regulations 3 and 12 to 15 in the Lawyers and Conveyances Act, Lawyers Practice Rules, Regulations 2008. Now, some key features of the regime, which we'll come back to in a bit more detail, include the prescribed recent legal experience requirement, 3 out of the last 5 years, we'll come back to that. The educational attainment requirement, which concerns the completion of a course and mandatory assessments prescribed by the Law Society, and that's comprised in the Stepping Up course, and David will be talking more about that. Now, importantly, there is an overarching requirement of suitability, so it is conceivable that an applicant could have satisfied the practical legal experience requirement and the educational requirement, but still be thought to be unsuitable. So I'm going to talk about suitability. Some of the other features of the regime are the separate ability to apply directly to the High Court, and I refer there to Regulation 13 and Section 30, subsection 3. Then a special circumstances category in Regulation 12A, which relates to people who have not strictly fulfilled the practical legal experience requirement. And there are some other aspects that we can touch on, but those are the core principles underlying what I've termed the regulatory regime. Now, just some other points before I pass back to David. Sorry, I'm getting behind on my slides. Just some other important introductory points. So, although the High Court process is available and is covered in the paper, it is inevitably the case that the vast majority of applications to practice on own account come through the Law Society pathway, and we'll be focusing quite closely on that. The other point that practicing on own account has some crossover with the practicing certificate regime, particularly where a person is applying to re-enter practice on own account from a period of absence from the legal profession. A person in that category would be required to apply both for a practicing certificate and to satisfy the Section 31 requirements, so there's some issues there. And the ability to impose conditions. Now, the High Court under Section 30, subsection 5, has a specific statutory ability to impose conditions on an entitlement to practice on own account. The Law Society can achieve much the same objective by way of undertakings. This normally relates to areas of practice and possibly some independent supervision and reporting in an early stage, something like that. Then just finally, in this part of the overview, the Practice Approval Committee plays an important role as a committee with delegated authority from the Board of the New Zealand Law Society, a group of senior lawyers who are involved in assessing and making decisions on what I would describe as non-standard cases. So there are cases where there have been perhaps professional difficulties in the past, all the special circumstances cases under Regulation 12A, and any other situation where there might be some difficulty or contentious aspect of the application. So with that, I'm going to pass back to David.
As I said in the introduction, when you're moving into practice on your own account, you're moving from the protected environment of being an employee. You're moving into an environment where you're responsible for not only providing good law to your clients and keeping your clients satisfied, but you also need to be aware that you're running a business and that you are going to be responsible for your own health, your own holidays, your family. You need to look carefully at your situation to make sure that you're going to be able to manage those things. Throughout this presentation and very much throughout the Stepping Up course, this notion of self-assessment will crop up. The onus is on you to assess yourself as you go through the process to ensure that you are an appropriate person to be doing what you're proposing to do, and that you're going to have the temperament and self-discipline to do that. The Stepping Up course, as I said, provides for all that, but because that's a big commitment in itself and an expense, we suggest that you do an initial self-assessment so that you sit down at the outset and look at yourself carefully. Do you have the appropriate temperament and self-discipline? Do you have good health? Are you willing to accept the financial commitment that there's going to be in committing yourself to undertaking legal practice on your own account? If you're entering a firm, are you willing to make the long-term commitment to that firm? And are you, is your family going to be willing to accept the longer hours that you're necessarily going to work, maybe your absences from family events, and the sort of commitment that they're going to be asked to make in terms of perhaps not so many holidays as you used to have, and maybe even a lower income initially, because it's not guaranteed that initially your income is going to be what it was as an employed lawyer. It takes a while to build up the momentum in practice. Oh, can I go too? Oh, did you? Sorry. So I suggest that you discuss your plans with your, obviously, family, friends and mentors. Just make sure that you are taking all the steps you need to take to ensure that you're going to be able to manage this. Importantly, engage an accountant, because from the time you go into practice on your own account, you're going to need to keep accountancy books. You're going to need, even if you're not undertaking to run a trust account, you need to run your own accounts. You'll have GST, you might have FBT, you'll have income tax, and on top of dealing with your legal work and your clients, you need to be sure that you're going to be able to cope with those things. So as I said, excuse me, undertake some planning and self-assessment, and take advice before committing to the time and expense that you'll undergo in the stepping up course. The stepping up course, of course, deals with these things very thoroughly, and I'd encourage you to treat it as a very valuable resource to equip you to go into practice on your own account. It's not just a regulatory requirement. Back to Paul now on the question of suitability.
Thanks, David. All right, at this point, we're going to look at the concept of suitability. It's very important because the other two strands of eligibility, if I could describe them in that way, are readily quantifiable. They are the educational and practical legal experience, although there's an element in the latter of judgment, which I'll talk about separately. But suitability as an overarching requirement is rather more amorphous, and so we need to look at that. It arises under Section 30, subsection 1, which requires an applicant to meet the criteria of practical experience and suitability, and similarly Regulation 12, subclause 5, that the lawyer must satisfy the New Zealand Law Society that he or she is a suitable person to practice on their own account. So what is a suitable person in this context? And as I observed earlier, you have already passed through the screening and met the standard of a fit and proper person through the admission and practicing certificate procedures. So there is something more, and that, as I said, is related to qualities that transcend or are different from issues of character, and include competency in matters such as handling client money, the operation of a trust account, and generally in running a business. Now, David will be talking about this a bit more, and the Stepping Up course focuses on it, but it is not necessarily the case that as a competent lawyer you are also competent at running a business, with all of the obligations of paying tax, possibly employment-related obligations, ACC, income tax, and so on. So suitability looks into that area as well, the ability to run a business. Now, I wanted to speak about some matters that will be taken into account, and if you are applying, which should be addressed in the application to demonstrate suitability. First, and perhaps very much stating the obvious, but I will say it anyway, reasonable competence in the law. Now, it is not the case that you have to show that you are a Class A scholar in all areas of the law, but that you need to be able to satisfy the decision maker that you have reasonable competency to practice on your own in the areas you nominate as your areas of practice. in your application. Now, that can be expressed broadly, such as civil litigation, or quite narrowly in a particular area, immigration or something like that. But whatever it is, you need to be able to demonstrate competency to inspire the confidence of the decision maker that you are able to practice in that area unsupervised. Now, the case I referred to in the paper is Ellison in the New Zealand Law Society. That is of interest because of its focus on the burden of proof being on the applicant to establish his or her suitability in matters of legal competency, and the possibility that an application would fail because of the inadequacy of the evidence about that, and specifically focused on referee reports from supervising partners or employers present in recent past. In that case, the applicant had not satisfied the Law Society, and he applied directly then to the High Court. And Justice Duffy, in hearing the case, actually granted an adjournment to enable the applicant to go off and get improved evidence to address legitimate concerns that had been raised by the Law Society, particularly where some reservations had been expressed by the referees. Another aspect of suitability is the applicant's complaints and discipline history. Now, I'm going to come back to the topic of what I call potential indicators of unsuitability. But in this area, it's important that you know that the Law Society is entitled to have access to an individual lawyer's complaints record, and is entitled to take it into account, even possibly where there were no adverse findings. So multiple complaints in a particular area might be indicative, for example, of immaturity or poor grasp of the rules of conduct and client care as indicators against suitability. So the Law Society is entitled to look at the record, and if you feel you have a problem about that, it is better to address it at the outset in your application, and I'm going to talk about hard cases a bit later, and we'll cover it there. I keep forgetting to use the slides. The importance of full disclosure in the application process is something I want to emphasise. So other possible indicators of unsuitability outside legal professional life, such as academic discipline in other occupations or in other jurisdictions, criminal background and so on. We're going to look at those a bit later, but they should be disclosed. I think that there is perhaps a greater peril for the applicant in not disclosing something than there might be in the matter being disclosed itself, because non-disclosure suggesting perhaps concealment or lack of candour would count against an assessment of a person being suitable. All right, so the main points about suitability are that it is the burden and responsibility of the applicant to establish his or her suitability, and they are matters transcending good character and fit and proper person, but should be focused on the sort of concerns the decision maker, which I will call in generic terms the Law Society or the High Court, could be expected to want to know about in being confident that the person was able to run their own business with those three strands that I talked about earlier: professional competence, ability to run a business, and ability to run a professional services business. Now, one other area of suitability I should mention before passing back to David is mental or physical health. and those are matters that the Law Society or the High Court is entitled to take into account. So again, a disclosure and explanation will be helpful in any application of those issues. All right. David.
Thanks, Paul. I'm now going to step through a process, and it wasn't intended to be a pun. I'll now work through a process of identifying the components that you're going to need to satisfy to move to practice on own account. There are three formal steps. The first is to complete the Stepping Up course. The second is to make an application to the Society for approval to practice on own account. And the third is towards the end of that process is to attend an interview. So the first of those steps is the Stepping Up course, which is a comprehensive preparation for practice on your own account. As I said a little earlier, not only is it a requirement for you to complete that, but it is an extremely valuable resource. It deals with a large range of the things that you're likely to encounter in the course of practice on own account, and it gives you a lot of tools that you can use later on in your practice, firstly in setting up, but then in continuing your practice. It's a self-directed distance learning course, which means you don't have to come into a separate place to do the course, although there is a 2.5 day workshop at the end of it. People have reported that they take 40 to 50 hours to complete reading the materials, doing the exercises, doing the observation. There are several online resources available as part of it as well, and it does take quite a lot of time. As I'll say a little later on in the presentation as well, you really do need to allow a good period of time. There's no point in saying a couple of months out from the date that you've been offered your partnership, I better do the Stepping Up course. You really need to get onto it early, because not only do you have to complete this course, but then you've got the application and you've got further processes to go through. As part of doing the course, you will prepare a business plan. I said earlier on that I recommend that you get an accountant to assist you, and this would be a good opportunity to do that. Get an accountant to help you to prepare your business plan, because you'll need to present that, and if your business plan doesn't look as though it holds water, you may not be approved. And also observing an existing practice's trust account. Now, you may say, well, I'm going to be a barrister, so I don't need a trust account. You will still need to do that, because all lawyers somewhere along the course of their practice will encounter the need to deal with client money. Obviously, as a barrister, you can't take the money directly into a trust account, so you need to know the rules around that, and that's part of the Stepping Up process, is observing an existing practice's trust account so that you understand what's involved. If you are intending to operate a trust account, or if you're intending to become the trust account supervisor of a firm, then you will also need to do the trust account supervisor course. It's not essential for going into practice on your own account if you're not operating a trust account, or if you're going into a firm where you won't be the trust account supervisor. But as an add-on, as an additional course, you will need to do it if you are going to operate a trust account. In the Stepping Up course, there are 3 separate modules, because obviously not everybody goes into practice on own account in the same way. If you're joining a firm of 3 or more partners, if you're practicing as a sole solicitor or in a 2-partner firm, or if you're practicing as a barrister sole. So there's some breakout sections in the course for those types of practice. The 3 essential elements of practice on own account are business management, And I know I keep talking about this as being a business, and I know that as lawyers we regard ourselves as perhaps being above all that sort of thing. But if you're going to operate a successful legal practice, then you must regard it as a business, and you must learn how to manage it. Professional conduct and client care, and this is where our responsibilities to clients come to the fore. We obviously are under an obligation to ensure that we comply with the rules as to professional conduct and client care. We're all bound by Section 4 of the Lawyers and Conveyancers Act. And then the third element, trust account management. So once again, to take each of these in turn, as I've said, a successful lawyer in practice on own account must be a successful business operator. You must have a workable business model and procedures. You must demonstrate leadership, particularly if you're going into practice as a sole practitioner. You must learn how to manage staff and finances. And you must learn how to manage clients' instructions and expectations, because not all clients are reasonable and compliant, and not all clients want to pay you either, for that matter. And you must learn how to deal with risk management. Obviously, professional indemnity insurance is one aspect of that, but that really is a safety net. You need to be looking at procedures within your office that will prevent business risk or regulatory misfortune descending on you. As I've said a moment ago, we're all bound by Section 4 of the Lawyers and Conveyancers Act. We're sworn officers of the court. We're required to uphold the law and facilitate the administration of justice, and we must at all times be aware of our fiduciary obligations. Some people think that running a business and observing fiduciary obligations to clients are not that compatible, but I can assure you that it is, and it's a matter of balancing those obligations and ensuring that you do remember always that you're a lawyer, but at the same time ensure that you operate your business successfully. Obviously, observing the rules of conduct and client care, which again are set out in the Act, and you must provide a copy of those rules and other information to clients in letters of engagement. The letter of engagement is an essential part of both risk management and client care, because in that you can set out the rules of engagement between your client and yourself. You are also advising the client of how they can raise a complaint if they need to, what they can expect of you, and who's going to be engaged in the work that you're doing. Just the wrong button. I suggest you don't make your letters of engagement quite that complicated. The third element is trust account management, and as I said before, this is a required element of the stepping up course, whether or not you're intending to have a trust account, because once you've got your ability to, or your approval to practice on own account, in one particular mode of practice, you may change in the future, so that you may go from being a partner in a firm where you are not the trust account supervisor and where you don't deal with trust account money at all, into a firm where a lot of, say, conveyancing or commercial transactions are done where money comes through. So you need to understand the rules about the management of client funds. In a firm, all partners are equally responsible. So the litigation partners can't say, nothing to do with me, you conveyancers can deal with the money. All partners are equally responsible, so you need to be aware of your responsibilities. If you accept or transfer client money without a trust account, or don't bank it to a trust account. Even if you accept a cheque from a client who says, look, would you pay this to Joe Brown, please, to settle my house purchase, that's regarded as handling trust money, so you need to be aware of those sorts of rules. The course will also deal with how to overcome the difficulty in receiving a retainer for fees. As I've said before, a barrister can't receive fees directly from a client, which means that a barrister can't take fees into their private account as a retainer for dealing with fees, for debiting fees as a matter goes on. Two ways of dealing with it. One is to receive instructions from a solicitor who has a trust account and can hold funds, and there is also an escrow scheme which is discussed in the papers and also has details on the Law Society's website. Again, as I've said before, if necessary, you may need to do the trust account supervisor course on top of the stepping up course. I took a course in ethics, but everything was contradicted by the course I took in accounting, not trust accounting, in accounting. I don't know about trust accounting. I think that would be all right. Again, I keep coming back to it. Self-assessment. Stepping up is a valuable resource to assist in planning and running a practice, but it's important also that you keep assessing yourself. It's not just passing the workshop and presenting a proper business plan and so on. It's a matter of assessing yourself as you go along and reflecting on the learning that you're doing, identifying areas where you are going to need some more work. If you need some more assistance with accounting, go and get it. If you need some more assistance with dealing with the rules of client care and conduct, then work on those areas so that you understand the balance between being a business person and a lawyer. And as I've said before, allow plenty of time. You need to look at the materials. There's quite a lot of reference to online materials in the papers, and you need to look at those and reflect on them. The application form, the current application form is appended to the webinar paper, but check the NZLS website for the current version, and I might say that it appears that there's a question in the current version that's repeated twice. Question 5G and H is exactly the same question, so don't rely on what I've attached to the paper. Go onto the website and look for the latest version of that. As I've said before, you need to allow time because the approval that you eventually obtain after completing the stepping up course and taking the other steps must be in place, and you must have commenced practice within 2 years of completing the stepping up, so that you not only need to complete the course, you need to have got your approval, and you need to have started to practice. So you need to just allow the time for doing that and ensure that you're going to be able to meet that deadline. As I've said in the paper, completion of the stepping up course is not a guarantee of approval. It certainly is a major element in supporting your application for approval, or requirement for your approval, but it's not a guarantee of approval. And I know of lawyers who have completed the stepping up course quite successfully, and because of suitability issues, have not succeeded in obtaining approval to practice on their own account. Once your application goes in, you're in a process that will take at least 2 months, and it could be more if there are special circumstances. References, and I think Paul will talk more about references. but references appended to form again appended to the webinar paper. But check the NZLS website for the latest version, and also read carefully the instructions about the referees, the appropriate referees that you're going to need. You'll need at least 2, preferably more, and they must be given by people able to comment with authority on your legal experience and competence in the last 5 years. They can't be from family members, and they must be from lawyers except in some exceptional circumstances. If you've been working in a firm, they must be from the supervising partner. We have some questions about people who've worked in government or other companies where the supervisor is not a lawyer. I think, Paul, you're going to mention that? Yeah, I'll leave that to Paul. And the references you obtain are only valid for 3 months. So, again, you need to look at your timing when you're dealing with when you're putting your application in, because if it's taking longer than 3 months, you may well be asked to provide further references. The other thing about the references is that that may not be the end of the story. The committee may come back to you and say, well, we want some more references than this, please. We're not satisfied with what you've provided us, and you may well be asked for further information. In the paper too, I've talked about topping up the Stepping Up course. If you have completed Stepping Up, but then have not succeeded in getting approval and setting up your practice within 2 years, you can go back and apply for a topping up. Of course, this is done by an online course, but it does save you all that extra work if you can. If you have this is a relatively new invention, I think, about 6 months ago, and it's designed to save you having to go back and do the whole Stepping Up course again. There's a lot of information in the paper. I suggest you read the paper rather than just listen to me, because there's a lot more there to discuss these things. But the last thing I want to discuss now is the interview. At the end of the process, after you've lodged your application, after your references have been accepted and any further information that appears to be necessary has been provided, you will then have an interview. The purpose of this is to establish if you're a suitable person to practice on your own account. So it's not just a matter of saying, yes, this person has finished the Stepping Up course. It's to establish if you're a suitable person in a global sense to practice on own account. And as we've discussed before, it covers business aspects as well as legal experience, personality, general suitability to go into an account. You will need to demonstrate an understanding of lawyers' duties and responsibilities. So again, the balance between running a business and being a lawyer with the responsibilities and duties that we have. I think I've mentioned somewhere in the paper that we are not legal technicians. We are sworn officers of the court, and we need to keep that in mind at all times. The interview will usually be conducted by 2 senior lawyers, one of whom will be a barrister if you're going into practice as a barrister, or if you're intending to operate a trust account, one of the Law Society inspectors will also be an interviewer. It's not strictly an examination, but your interviewers will work through a checklist of questions to ask a number of questions about your understanding of your duties and responsibilities as a lawyer, your understanding of trust accounting principles, ethics and client care rules, they will want to look at and perhaps discuss your business plan and ask you, for example, where you intend to get your work from, because work doesn't just flow in the door. You need to go out and get it, and you need to be able to show that your business plan is workable and that you will have a supply of work that's going to provide you with a reasonable income. The last thing we want is for your practice to fail. You will probably also be asked about any complaint history, and those matters will be discussed. If there is anything unsatisfactory in your complaint history that isn't reconciled, your application may finish up with the Practice Approval Committee, but again, be prepared to discuss that. And finally, the interviewers will probably discuss pastoral matters like mentoring, like the Law Society's good practice initiative, using library services, and the Friends panel, for example, discussing how you're going to manage your time, give yourself proper holidays, deal with risk management, and so on and so forth. So it will be quite a wide-ranging discussion. But as I've said, it's very important to prepare. Following the interview, your application goes to a panel which, under delegated authority, will decide whether to approve your application to practice on own account. The interview panel does not make that decision. If the interviewers decide that you're not a suitable person, then it's very likely that your application will not be approved. But even if they do, there may be aspects that the approval panel may still have some doubt about and want to ask further questions or get some further information about. In some circumstances, it may be referred to the Practice Approval Committee, which will also require further information, may want to conduct a further interview. So all in all, as I've said there, allow plenty of time. It's not something that can be rushed, and applications that allow a few weeks or a couple of months are risking not getting through the process in time. Back to Paul.
Thank you. I'm going to talk about recent legal experience and that aspect of the requirement, but before I do, I just want to acknowledge that there are a lot of questions coming in, which is excellent. They're coming in like electronic confetti raining down upon us. So I do want to give a good amount of time to answer those for a webinar of this sort. It's unsurprising that a lot of the questions are focused on individual concerns or reflecting individuals' experiences in this area. So we will do our best to answer those and give adequate time for that. So thank you for your questions so far. And just one that came in, and I'll just quickly answer it now. Do presenters intend to refer to the High Court decision in Skagen, the Wellington Standards Committee? This relates to David's earlier point that all lawyers, whether they're practicing as barristers and solicitors or with or without a trust account, all barristers must have an appreciation of trust accounting principles and the legal requirements for handling and recognising trust money when it comes into your hands. So we weren't going to focus on the case, but that case dealt with that topic and a barrister receiving payments in advance fees, and I'll do a bit of shameless self-promotion and refer you also to my article on that in a recent edition of Law Talk concerning lawyers' responsibilities when receiving payments for fees in advance, and whether indeed it is legitimate to receive payments for fees in advance of the work being done, other than into a trust account. So that just highlights the point that all lawyers who are wanting to practice on their own account need to have an appreciation of trust accounting principles, and you should not think that you can escape that just because you're going to become a criminal defence barrister or some such. All right, I'm going to talk about recent legal experience now, and this is an important fundamental feature of the practice on own account regime. It arises under Section 30, and I've got the references there, subsection 1, the practical legal experience requirement. Legal experience, which is defined in 7 categories in the in Regulation 3, of which I think 5 categories refer to legal work. The 2 that do not work as an academic, a legal academic at a university in New Zealand, and work as a member of Parliament. So the other categories of legal experience all involve the concept of legal work. And then Regulation 12, subclause 3, concerns the required minimum recent legal experience, and I'll talk about the timing aspects of that requirement in a moment. So if you look at Regulation 3, and incidentally all of the regulations and sections 30 and 31, of course, in the papers in the paper for this webinar, but Regulation 3, 1A to G is the various categories of legal experience, and Regulation 12.3 is the requirement that the lawyer must have had at least the required minimum amount of recent legal experience, and then you have to go back to the definitions provision to determine what the required minimum amount is, and that's your 3 years out of the last 5. I'll focus on that at the moment. Legal work is also a defined term in the Lawyers and Conveyancers Act, and I won't laboriously go through that, but it covers, of course, the reserved areas of work, legal advice, creating legal documents, and any work incidental to those categories of work. So you can expect that in assessing an applicant's recent legal experience as qualifying experience, the focus will be on the nature and quality of the work and whether it was in fact legal work. Importantly, and this is an area that was litigated to some significant extent in the era of the Law Practitioners Acts of 1955 and 1982. The nature of qualifying legal work was very much focused on the need to have worked in a supervised environment in the hands of more senior lawyers, to observe how more senior lawyers carry out their work, and to have been properly mentored and tutored. I've referred to some cases in the papers, but Illingworth and Auckland District Law Society is a case from as long ago as 1977, where the court emphasised the need for a person to be in a law firm, working with experienced people with the chance to observe and learn by instruction and by observation of more experienced people. However, in the Lawyers and Conveyancers Act era now, we really must focus on the specific categories listed in Regulation 3, and my view of those is that they tend to shift the focus very squarely onto the legal work rather than the form of enterprise in which it is occurring. So we've got different categories: the routine legal work for a lawyer in sole practice or partnership or incorporated law firm, legal work as a barrister, if the barrister is applying to practice on own account as a barrister and solicitor. Then you've got legal work in the state sector or with a local authority, and legal work with a company or any other entity, or any other body rather, So the emphasis is on the quality of the work rather than the nature of the enterprise in which it's occurring. However, I would add that obviously the quality of your evidence supporting your application and the part which focuses on satisfying the recent legal experience part of the requirements will need to explain in perhaps greater detail what the quality of the legal experience has been, where it is not so readily self-evident. So if it's in a corporate environment outside of a legal practice, you'll need to show what tutelage, what supervision you've had from a more senior lawyer. Interestingly, and I must admit that I found this interesting in the context and preparation of this paper, that had not occurred to me, but pre-admission legal work may be taken into account. So you get the legal executive, for example, that's been working for many years in a firm and has chipped away at a law degree part-time and finally gets through and gets admitted and is issued a practicing certificate. Well, he or she may well be able to accelerate progress to practice on own account if the quality of that person's experience as a legal executive reaches the level of satisfying the Law Society that it is qualifying legal experience. So it is not necessarily the case that there is a stand-down period for 3 years after you've been admitted and first issued with a practicing certificate. Nevertheless, the focus is on the nature and quality of the work experience and the degree of supervision. Just turning to the timing requirement, we've heard that it's 3 out of the last 5 years in aggregate, involving a maximum of 40 hours per week. And in my paper I say, consequently, the legendary 80-hour working week will not accelerate fulfillment of the requirement. So we all know stories of people who work every hour of the day and go home to sleep for 2 hours and come back and start all over again. That will not accelerate your fulfillment of the timing requirement. So a maximum of 40 hours per week will count, and the total requirement measured in hours is 4,830. And I can ask Sarah later whether anyone actually brings a timing record to that extent. But so the regulation is as particular as that. That's the recent legal experience requirement. I want to talk now about the special circumstances concept in Regulation 12A. It is related to my last topic of recent legal experience because it is an exception where a person is applying not having fulfilled the 3 of the last 5 years legal experience, but nevertheless thinks that he or she should not be kept out because of kept out of practice on own account because of a rigid approach to the 3 out of 5 standard. So 12A exists to accommodate special circumstances, and importantly, it is intended to overcome difficulties with the timing requirement, but the educational requirement still prevails. So you still must have done the course of instruction, the stepping up course, within the last 2 years prior to intended commencement of practice on own account. Now, Regulation 12A applications automatically are passed to the Practice Approval Committee, so if you're applying in that category, then you can expect that there will be a reasonably intense level of scrutiny about the circumstances that you say are special and that mean that you ought to be excused from the more rigid approach of the 3 out of the last 5 years. Some examples I've set out there: absence on parental leave, but continuing connection with legal work, you'd have to show evidence of perhaps a significant amount of part-time work, attendance at CLE courses and the like. Falling short by a narrow margin, but having worked part-time consistently throughout the period would be a possible special circumstance. A combination of New Zealand legal experience and a comparable overseas jurisdiction, and a junior barrister practicing under an approved scheme. So that the burden is on the applicant to satisfy, in this case, the Practice Approval Committee, that the circumstances are genuinely special, and that the decision maker, the Practice Approval Committee, can be confident that, notwithstanding non-compliance with the 3-5 requirement, you are a person who can safely be authorised to practice unsupervised. Now, if you are going to make an application in that category, I've said in my paper that you ought to accompany your paper with a personal statement about why the special circumstances are said to apply, and why it is that the Practice Approval Committee can be confident that you are nevertheless safely vouched to practice on own account. I think too, another element to this is that you would need to have had more than 3 years legal experience in a global sense to qualify under that provision, going back further in time. So that is correct, sir?
Yes.
All right. Now, non-standard applications. This is my all-embracing and non-judgmental term concerning potential indicators of unsuitability. So this can involve past legal disciplinary history, but it may also involve, again, the neutral term, potential indicators of unsuitability arising elsewhere, including past criminal convictions, discipline overseas or in other occupations or in academic life. Bankruptcy are examples of what I term potential indicators. This goes to the matter of suitability, which I talked about earlier, and I told you earlier that the Law Society is entitled to have access to complaints and disciplinary history, but so may be taken to know about that. But even so, in your application, you should make a clean fist of anything that you think might be an indicator against, or against your application, or that at least warrants inquiry. And the peril of non-disclosure is itself a potential area for difficulty with you if something comes out later. Now, just how might these be relevant? Well, numerous complaints can suggest professional immaturity, adverse history relating to dealings with money, which would include perhaps distant past criminal convictions, subject, of course, to the Criminal Records Clean Slate Act. And so a situation like that might put the Law Society on inquiry to possibly requiring an undertaking, or that you not be permitted to operate a trust account. I've listed the other items there and won't just read them out, but importantly, you will have passed through the screen of fit and proper person because you're already in possession of a practicing certificate. So the adverse indicators must be considered specifically in light of your aspiration to practice on your own account. And if you think that you might have a difficulty or you're disclosing something and you really want to explain why it is that this should not be held against you, then again, I think it would be wise to have a personal statement explaining what happened and why. And I've referred there to case L in the Canterbury District Law Society. That was in fact a case about a lawyer applying for approval to resume practice on own account after having been ordered by the disciplinary tribunal to practice only as an employed lawyer, and that's an oldish case now under the Law Practitioners Act. But similarly, under Section 241 now, 242, the disciplinary tribunal can make an order refusing you the entitlement to practice on own account. And the test for being permitted back, I think, is useful, not so much because we're not so worried about the disciplinary tribunal in this webinar, but application to the Law Society. The test is whether the decision maker, the Law Society or the High Court, can be affirmatively persuaded that the past blemish which resulted in the inability to practice on own account no longer applies. So in this case, that a past blemish is not going to be repeated and cause difficulty when you are permitted to practice on own account. So focus on restoration, long time serve with a good record, youthfulness of the indiscretion or whatever happened. My next slide is concerned with practice on own account under Section 31, which is recommencing. So this is the category of case where a lawyer has been approved at some point in the past and now wishes to re-enter practice on their own account. There are three categories that are considered under this section. Subsection 1, where the lawyer was approved to practice on own account under the Law Practitioners Act immediately before the commencement of the Lawyers and Conveyancers Act. I won't focus on that too much. The second one is important, where under Section 31, subsection 2, where the lawyer has been approved to practice in the past on his or her own account and wishes to return to practice in that status, subject to a 10-year time limit. Now, this will arise either because the person has been practicing as an employed lawyer but wishes to go back into own account status, or where the lawyer has been out of legal practice for a time. Then the other category is where the person has been not practiced on own account for more than 10 years. In that case, there's an element of an evidentiary requirement to establish to the Law Society that they've received adequate instruction in the duties of a barrister or barrister and solicitor. Excuse me. So qualification in the first two of those is automatic. If you have been approved to practice on your own account in the past, within the last 10 years, and wanting to return to that status, all you have to do is apply for your practicing certificate in that category and submit your evidence concerning your former approval, which no doubt the Law Society Registry will have anyway. The other category, over 10 years, does have a qualitative aspect to it, but I suspect not many of our audience will be too concerned about that one. I just want to make a point about this, that if you are returning to practice from a period of absence, this area introduces the crossover of approval to practice on own account and practicing certificate approval being the test of fit and proper person. So to re-enter practice, you have to have a practicing certificate and you have to satisfy that requirement. That can introduce a different level of scrutiny, and it's conceivable that you may be refused a practicing certificate to practice on your own account if there are adverse indicators or concerns about that. And I've referred to a case where issues of that sort arose in a Section 42 appeal against the refusal of a practicing certificate in J in the New Zealand Law Society, and it's in the paper. So we're going to go to question time in a moment. My last topic is the one of entitlement based on eligibility in Australia. And again, I suspect very few of our audience will be relying on this one, but it deserves mention. This is the counterpart to the Trans-Tasman Mutual Recognition Act provisions in sections 39 and 49 of the Lawyers and Conveyancers Act, where practicing certificates and admissions can be gained on Trans-Tasman Mutual Recognition grounds. In the area that we're concerned about today, practice on own account, if you can establish that you are permitted to practice on your own account or an equivalent concept in an Australian jurisdiction, then you will be permitted to do so in this country, and that is a matter of satisfying the Law Society about your entitlement in an Australian jurisdiction. So I think we're going to move to question time now, and this is quite an important session. We introduced Sarah before, Sarah Inder, who I think is particularly important in this concept because David and I are speaking about legal and with David's views on it for insight into the practical side of it. But Sarah is on the workshop floor in this area at the Law Society with her work with the Practice Approval Committee, so can help me contribute. We have a lot of questions, and I really want to move through them quite quickly to be fair to people.
42 so far.
42 questions. Well, there's a challenge.
Sorry, 45.
45, and some of them are pretty clearly. So, look, I think I'm just going to pick them up and get going. Is that how we would like to do it?
Yes.
So thank you again. All right. If you've been working part-time, approximately 15 to 20 hours per week for the last 10 years, will you satisfy the minimum recent legal experience requirements? Well, I'll give my two positives here. That because of the quite specific requirement of the 4830 hours, I think I got that figure right, and the 3 years after the last 5, which is quite prescriptive. If you did not reach that threshold through your part-time work, I think you would be in the special circumstances category of applicant under Regulation 12A. Is that your view of that one, Sarah?
Yes, that's correct.
Yeah. So there's something of an arithmetical quality about this, totaling up the time worked. And if you don't reach it because you've been working part-time, then I think you would be a candidate for special circumstances. So, David, do you want to do the honours with another question?
Yep. I think I covered this before. A couple of people have asked what is the difference between questions 5G and 5H in the application form. The answer is none. It's a typo. Please download the latest version of the form. I want for Sarah, where is the membership of the Practice Approval Committee available?
It's not actually set out anywhere. If your application is for the Practice Approval Committee, all correspondence and questions should come through me as the secretary, and I can advise you who the membership is for the particular committee that your matter is before.
It's important. There's not a cloak of secrecy about this. It's a process open to scrutiny, and if you want to know who they are, then you should ask Sarah. Also, I think you can rely on the members initiating any issues about conflicts or compromising influences if they're too close to the applicant or some such thing. All right. Sarah, you had one that you particularly wanted to focus on. So in a situation where an individual has worked only for one employer in a single partner practice, so working for a sole practitioner during the entire, let's say, 5-year period, or at least 3 years, what other referees or references may be suitable? So that this goes to the issue of the quality of references. And what do we look for? We look for the person who has the authority and the standing to make judgments about your capability of working unsupervised and to practice, therefore, on your own account. And that might be, for example, a lawyer who got to know you in a court case or a transaction, if it's a transaction or conveyancing practice, barristers that you've briefed and worked with. So you might have briefed a senior barrister and worked closely with that person. His or her reference would be helpful. If you're a barrister, then you're instructing solicitor. It's important that the person be familiar with the work that you've done and to be in a position to assess the quality of that work.
There's quite a few questions relating to references, all similar of that nature, and who they should use as referees. I'm happy for you to contact me to discuss that directly in regard to your specific circumstances.
Sarah, do you think there is a statement you can make now about some common themes with difficulties in this area that might help people with references?
Well, one of the ones that we've just talked about where if you're working for a sole practitioner, you've only got one there. Another question we've had is related to someone who's been employed by a family member in their sole practice, which references are not generally allowed from people related to you. In that situation, we would still be interested to hear from that referee because they have been your employer, but we'd have to look at what weight it's given that they are related to you, and in that circumstance, we would require that you submit at least another 2 references. Other situations maybe where they have been practicing as barristers that weren't required when they started to be approved to practice on own account, are now wanting to be approved to practice on own account as barrister and solicitor. So they won't have had employers or colleagues even in their barrister practice. So again, people that are familiar with the work from acting on the other side, or perhaps instructing barristers and solicitors that are familiar with the quality of their legal experience and also can comment on their suitability to practice on own account.
Thank you. Can I answer one? Someone's asked a question about lawyers referring to their profession as a business and how conscious should lawyers be that it is not a business, and conventional interpretation of that term is more of a profession which puts ethics, morality and professional behaviour as on top, unlike many other businesses. I absolutely agree that we do need to put those things on top. We do need to ensure that ethics and fiduciary obligations are on the top of the priority list for us. But we're not going to last long in practice on our own account if we don't apply sound business principles. So while, yes, we are a profession and yes, we do have those professional obligations, we must also be underpinned by sound business principles.
Can I add to that? And I'll wear my hat as legal counsel experience in professional disciplinary matters. It is absolutely the case that you need to be competent in running a business, as a commercial enterprise, if you are going to be practicing on your own account, especially genuinely self-employed, either as a sole practitioner, barrister, and solicitor, or barrister. Believe me, every other day there's another tax obligation or some form of compliance rolling in at you. You have to be on top of these things your employment arrangements and the management of your staff. If those things are neglected or not run well, they drag down the professional side of your business. And again, in the disciplinary arena, there is something of a common theme of lawyers who have become overburdened with the administration of a practice, and that's tipped over into their professional lives. So I emphasise strongly, although of course we're here to espouse notions of professional responsibility, pure commercial responsibility is an essential feature of this area. Now, there's a question: is it worth submitting a reference from a non-legal supervisor if you are in-house counsel? Now, I want to just use that one, perhaps, because I believe there are quite a number of attendees who are from either public service, government area, or local body, or in-house counsel. Sarah, could you just give us an outline of people who are practicing in-house, supervised or unsupervised? How does this regime work for in-house lawyers, and what sort of supervision would you expect so the person is applying for practice on their account status from a commercial environment, let's say a bank or an insurance company?
In relation to what references we require?
Yes, and the confidence you need to know the quality of the legal work experience at the in-house counsel setting. I'm sorry to put you on the spot, but perhaps we go back to the question: is it worth submitting a reference from a non-legal supervisor? Let's say you work in a construction company and you're running the Construction Contracts Act administration and dealing with legal issues of the full range that would happen in a construction company, but your main boss is an operational manager of construction.
Well, we would want a reference from your boss, from the manager, as to what legal experience for them you had, but we would still require them from lawyers, preferably practising on own account, who can comment on the suitability issue and whether you're suitable to practice on own account. In regard to satisfying us regarding the experience from in-house, there is, of course, a case that you referred to, Paul, in the paper there about that. The issue is that it's quite different from working in a law firm, in that as an in-house lawyer, you're restricted to only give advice to your employer, so you haven't had the same client relationships as you would have had in private practice. That's just one of the issues that we look at. So you would need to, it would usually be that it would come under a special circumstances application, perhaps if they didn't meet that 3-year and 5, and they would need to set out exactly how they're going to cope with working in a legal environment, a legal practice environment, different from what they've been doing in the past.
Right, thank you. Got a good one there.
I did have one, I've lost it. Here it is. Someone has asked about, I won't read the whole question because it's quite long, about mentoring and suggesting that the Law Society might think of providing a paid mentoring service and also trust accounting services. My suggestion would be for somebody who perhaps hasn't been in the country for very long, although you will have to have been practicing for 3 years within the last 5 to be applying for practice on own account, and I would have thought you'd have got to know a few people in that time. But I would suggest that you do one or do both, if you like. One is to contact the Friends panel at the New Zealand Law Society, who could put you on to somebody to discuss your particular problem. I don't think you'll get a permanent mentor that way, but you could discuss that with somebody perhaps in your area, perhaps with your type of experience in your type of practice who can make some suggestions for you. And the other is to contact your local branch of the New Zealand Law Society. The legal profession is very collegial, and the local branch will know a lot of lawyers in your area, can probably suggest somebody that you can talk to, can probably suggest functions or different things that you can go to meet other lawyers and make connections that way. So I'd suggest that those are the ways of approaching that, just getting to know as much as possible the other lawyers around you, so that you do have people that you can contact. I suppose this isn't quite the right medium to be saying this, but rather than listening to or watching as you are webinars, actually go to live seminars where you can meet other lawyers who are practicing in your area.
Right. Thanks, David. One point of clarification in the Section 31 aspect of my presentation, the requirement to be eligible to return to practice on own account under Section 31(2), which is the absence from legal profession or not practicing, or practicing as an employee. The requirement is that you have actually practiced on your own account in the past, so in the past 10 years. It's not just approved. So just to clarify that point. And if you are wanting to come back, you would need to look closely at those provisions, because they are important and there's a mandatory element to them, but you need to satisfy the requirement. All right. Does the TTMR, the Trans-Tasman Recognition Act, permit lawyers in NZ who are approved to practice on their own account in NZ to practice in Australia? The answer is, I believe so, yes.
Yes, of course Australia has their own Trans-Tasman Mutual Recognition Act, but like ours, it looks at equivalency. So in New Zealand, practicing on your own account is deemed to be equivalent to practicing under an unrestricted practicing certificate in Australia.
Right. Sarah, did you have one there that you thought about illuminating?
Yes, there's a few questions about being a consultant. Can you be a consultant contractor in a firm and be practicing on your own account? Yes, in fact, if you are not under an employment contract as a consultant, you are required to be approved and practicing on your own account. And a similar one to that, what is the situation in becoming a locum lawyer when you are not entitled to practice on your own account? Well, again, if you're not entitled to practice on your own account, you have to be practicing under an employment agreement.
And perhaps I could just mention too, there was another question very close to that. If you're employed by a company, not a legal practice, as their sole lawyer, are you classed as practicing on your own account, even though you're employed by a company and not operating on your own? You're okay as long as all you're doing is advising the company. But if you are advising outside clients, then you do need to be approved for practice on own account. So you can be an in-house company lawyer advising the company, no problem, but you need to be approved for practice on own account to advise outside clients.
Now, I'm getting nods and winks from the other side of the camera. I think our time is running out. Do we have time for any more?
One more if you've got time.
Okay, can I ask, I'll put it to my colleagues here, the status of a salaried partner. Now, that's an internal arrangement within a firm as to how its partnership is structured. There was a question from a person about their eligibility to practice on own account to return to that status after having been a salaried partner. It wasn't clear to me whether the person had been, in fact, approved to practice on an own account in the past. But in my view, if you are held out as a partner, regardless of the internal arrangement within your partnership as to remuneration or responsibility within the partnership, you must be approved to practice on your own account. So salaried partners are people who should be approved to practice on their own account. Is that right, Sarah?
Yes, that's correct. And if you were looking, so if the person had been practicing as a salaried partner, that is, they've commenced practice on own account, then they wouldn't have to do any further qualification if they were within the 10 years under Section 31(2. They could recommence doing that. It would only be if it was more than 10 years that they would have to look at being assessed as to what qualification or further instruction had to be undertaken.
Thank you. Now I'm going to hand back to Alex.
Thank you. There's been quite an influx of questions. For further specific inquiries, please contact Sarah Inda, Secretary of the Practice Approval Committees directly. You'll see her direct dial and email address listed here, and these will be included with the archive copy of today's presentation. Now, thank you to Paul and David for a really interesting and instructive presentation, and our thanks to Sarah for being available to answer some of these more specific and slightly curlier questions. You can access a recording of today's webinar via an archived copy of the presentation by logging onto MyCPD. Further instructions on how to do that will be emailed to you tomorrow. The same email will also give you an electronic certificate of attendance for your CPD records and a link to an online evaluation. We'd really appreciate it if you could take a couple of minutes to complete that evaluation to let us know what you thought of today's webinar. The webinar has now concluded.